Thank you very much. So my topic is fintech, and fintech is a term that combines finance and technology and refers to the use of various technologies such as digitalization, blockchain, AI, smart contract, and APIs to provide new and higher quality services. Fintech covers a wide range of areas, including payment, loans, securities, crypto assets, insurance, asset management, and crowdfunding. Although fintech is a diverse and wide-ranging, some features common to many fintech brings a variety of challenges to private international law. Today, I will focus on issues relating to distributed ledger technologies, typically blockchain, and want to talk about 4 topics: location, automation, regulation, and law and technology. First of all, the rise of blockchain-based transactions caused the difficulty to identify locations. I want to talk about 2 situations. First is a criminal case. There is a Japanese lower criminal court case in which persons were indicted for computer fraud after receiving the cryptocurrency that had been stolen from a cryptocurrency exchange. Under the Japanese criminal code, in order to be penalized for criminal fraud, it is necessary for computer fraud to have taken place in Japan. The court ruled that the result of the computer fraud had occurred in the place where the node that shared the false information were located, and that at least one of the nodes that had shared the false information was located in Japan. Then it was concluded that computer fraud was committed in Japan. I could agree with the conclusion, but the reasoning seems to be too technical and recognize too widely the place where the result have occurred. It would be more reasonable to look into the location of the party who suffered the loss to check the territoriality of the crime. The second is the governing law of the proprietary aspect of cryptocurrency. I understand that this point has been already discussed here at CODIFI. About property law issues related to asset recorded on blockchain, there are at least 3 issues to be considered: the relationship between the interest in asset and the record on blockchains, the transaction through intermediaries, and connecting factors. For the first point, there are 2 types of crypto asset or tokens. Tokens that relate to something outside of blockchain, such as immobile property, movable property, personal claims, or other digital assets, typically NFT. And tokens that do not relate to something outside the blockchain, typically Bitcoin. In the former case, the extent of the legal connection between such assets and the record of the blockchain should be determined by the governing law of the asset associated with the tokens. If the law applied to the asset says there is no link between the title or the transfer of the asset and the record of the blockchain, then the proprietary aspect of the asset should be governed by the law applied to that property under the conventional private international law rules. Next, in considering private international issues relating to transaction using blockchain, it is important to distinguish between cases in which the interest of persons using intermediary is at issue, and the cases in which the persons directly connected to blockchain with the use of the intermediaries. Main transactions relating to cryptocurrencies are conducted through intermediaries, such as crypto asset exchanges or custodians. In the former case, the situation is the same as or similar to when the governing law of indirectly held securities becomes an issue. So I think that the reference to Hague Convention on the law applicable to indirectly held securities would be useful. In the latter case, there are various views how traditional lakeside rules should be modified in each blockchains have been discussed. First of all, it is not appropriate to focus on the location of the private key or wallet because such private key is just a number and can be easily duplicated and moved. The reason why location of assets have been used as a connecting factor for property law issues are objective and easily ascertainable. Second, has better control over the asset. And third, reasonably reflect the reality of the system as far as possible. Considering the variety of crypto assets, no single rule could cover every situation. And as Professor Lehman suggested in his presentation yesterday, I think a waterfall framework should be considered. What kind of waterfall? First, where the participants in blockchain choose the governing law, that law should govern the property law issues. This includes not only the case where parties agree on applicable law to property law issues, but also the case where parties agree to applicable law to contract issues. In the latter case, the coverage of governing law of contract should be extended to property law issues unless parties have expressly agreed otherwise. There may be some discomfort with the law agreed by some parties to discipline property law issues, but such cases already exist in other situations and are not unacceptable. However, one caution. At least concerning the distributed ledger, which plays an important public role, such as an essential system in financial market, it is not appropriate to allow completely free choice of governing law in order to ensure the blockchain is under proper legal order. In such case, a choice of law should be subject to regulators' approval. Even in cases where there is no choice governing law by parties, if it is clear that there is an administrator who plays a central law, such as having a certain authority in the system, it may be appropriate to use the location of the administrator as the connecting factor. This is because if there is an administrator known to the participant, using the administrator's location as the connecting factor seems to be appropriate to provide clarity and predictability. Also, it would be expected that the location of such a key player might have better control over the blockchain or asset than other locations. If neither of the above two linkages can be found, then the law of the location of the persons who actually has the power to dispose or transfer the crypto assets by making a necessary change of records should be used as a connecting factor. Given that most legal disputes occur between persons who actually exist, even if the transaction takes place on the internet, there is a good person to focus on the location of the person who can actually dispose or control or transfer the tokens, and it would contribute more effective resolutions of the dispute in a real world. Finally, for example, when person A and person B enter into a contract relating to crypto asset recorded on blockchain and a dispute about the ownership or proprietary aspect of the asset occurs, applying the law governing the contract between party A and party B also to issue of ownership or property law issues seems to be more natural, because the law have the closest relation to the dispute. Next, I'd like to touch into the automation issues. Blockchain makes it possible to record computer programs of the blockchain and create a mechanism whereby contracts and transactions are carried out according to those programs without human involvement. Such a system where contracts are automatically concluded and executed based on computer programs recorded on the blockchain is known as smart contract, as already discussed today's session. The result in that issue of automation of transaction. For example, the question may arise, how the rules of determining the applicable law or jurisdiction by focusing on human intention should be applied in relation to contracts made without human intervention through smart contracts. In many cases, it will still be sufficient to look into the intention of the person or legal entity using smart contract. However, if substantive law starts recognizing separate legal entity to mechanisms using such smart contracts, the private international law would need to consider the next step. For example, in the world of decentralized finance, known as DeFi, automated organizational mechanisms, known as DAOs, are being used. In such DeFi, transactions are fully automated using smart contracts or DAOs, and parties to transaction do not have to reveal their identity as long as they provide sufficient collateral to cover various risks. There, it is very difficult to identify live persons. Some jurisdictions start recognizing their legal personality for these automated systems. Do countries that do not recognize the legal personality of such DAO recognize the legal personality of DAO formed under the law of a country that does recognize their legal personality, whether through the governing law or of incorporation principle or through other approaches? We normally recognize legal personality formed under the law of other countries without any specific scrutiny. But when it comes to the legal personality of an organization such as a DAO, it would not be easy to recognize it because it may involve the basic legal principle of the respective society. Third, the application and enforcement of regulation and supervision. A key feature that distinguishes the financial sector from other sectors is that regulation and supervision play a very important role in protecting users and stability of the financial system. Even in relation to traditional financial transactions, issues such as extraterritorial application of securities law have arisen. However, Fintech is creating significant challenges for such regulation and supervisions. For example, in July 2022, Financial Stability Board announced that statement on international regulation and supervision of crypto asset activities. It says crypto asset service providers must at all times ensure compliance with existing legal obligations in jurisdictions in which they operate. However, it is not easy to subject crypto asset providers operating in the online world to proper regulation. There are some reasons. Firstly, the attitude of countries to crypto assets differs from one another. This allows crypto asset providers to base themselves in less regulated countries and do business all over the world. Furthermore, when there is no issuer with administrators or intermediaries, or all transactions are fully automated using smart contracts and DAO, who should be regulated is also very difficult issues. Even if a foreign service provider is identified and countries want to regulate that provider, it is often difficult to do so in practice. For example, under Japanese law, a person who intends to engage crypto asset businesses shall make registration, and foreign service providers do not register under the Japanese Act must not conduct solicitation of a person in Japan for their business. According to the Japanese regulator, the act of a foreign crypto asset exchange service provider posting advertisement on its website regarding crypto asset business constitute solicitation of a person in Japan, except in cases where the website clearly shows that the service is not provided to a person in Japan, or where the service provider takes necessary measures not to transact with a person in Japan, such as by checking the location of its customers. It seems too broad to apply Japanese regulation in such a way. However, considering that many individuals residing in Japan can make a transaction with the unregistered foreign entities easily through internet, such extraterritorial application would be necessary to protect people in Japan. However, it doesn't mean that such regulation, extraterritorial application of Japanese regulation is effective. Based on this rule, Japanese FSA supervisor has issued warnings to 11 foreign businesses for conducting crypto asset exchange services to Japanese residents via the internet without registration. However, as far as I know, there are no responses from such foreign service providers. Cooperation between regulators in different countries is essential to increase the effectiveness of regulation on crypto assets. Finally, I'd like to conclude my presentation by touching on the division of labor between technology and law. When the use of DLT makes it possible that everything is done on the internet and according to the predetermined computer programs, there is a fundamental question whether there is a room to apply the law, which is based on the existing judicial system, and whether it can be enforced in reality, even if it were to be applied. If this happens, one might think that instead of maintaining order by law, it might be better to rely on technology to maintain various orders. This is a problem in the world of substantive law, and it may be said that private international law has nothing to do with it. However, if the substantive laws that is to be applied doesn't function at all, it may still be a problem in the world of private international law as well. So private international law also needs to consider how the division of law and technologies should be. Thank you very much.